Hello, welcome to the Law Professor once again. In this presentation, we shall be looking at another aspect of dissolution of statutory marriage under the Matrimonial Causes Act of Nigeria. We have established in the previous presentations that the Act states that a marriage can only be dissolved if it can be established that it has broken down irretrievably. And we have laid the foundation that the components of what represents irretrievable breakdown of marriage can be found in Section 15.2 of the Matrimonial Causes Act. Today we shall be looking at Section 15.2c, which talks about behavior and the fact that a petitioner cannot reasonably be expected to live with the respondent. So what does that mean in law? How do we identify that kind of the kinds of behavior, and what are the expectations of the law with regards to the person that is claiming that the other spouse has behaved in a particular manner? So to do that effectively, therefore, what we'll be looking at essentially in this presentation is to look at Section 15.2c, how it defines the element, or how it creates the elements, the components of the elements, the interpretation by the courts, and laying emphasis on what some of the salient points that I should watch out for as a student in this area, or as a practitioner that is defending a case or petitioning a case in court. Now, the Section 15.2c says that since the marriage, the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with. That's if you are able to establish that, then you would have been able to prove that the marriage has broken down irretrievably. The word since connotes that it is behaviors that happen after the marriage that are in consideration. We are not looking at what they've done to each other before the marriage, but rather what happens once they are pronounced as husband and wife. Then it requires that therefore there is a behavior, and a behavior is such that it's intolerable. Behavior is undefined by the Matrimonial Causes Act. You cannot find where it says the meaning of behavior is this, but it gives examples of some facts that represent behavior under Section 16. I shall be looking at those facts. Now, from the cases, you could say that behavior represents that the acts of or conduct of one party which has an effect on the other party. And usually such acts are usually grave and weighty. The law knows that we are all human beings and there is nobody that is perfect. But within the confines of marital life, there are some expectations, and there are some things that no reasonable person will expect to take place. So behavior in some cases have been described as something that is grave and weighty, and that is such that has an effect on the other spouse. And in the case of Cohen and Cohen, the court held that in looking at the facts before you, look at what has the respondent done or has not done, what has he failed to do. And when you look at that, you examine the effect on this particular petitioner before you. And that petitioner with their habits and personality, whether it's a gentle person, timid person, quiet person, that's a subjective aspect of behavior. Then you now examine whether is it reasonable to expect this particular petitioner to continue to live with this kind of behavior. So there's now an objective component of this behavior that we are talking about. So there's a subjective objectivity or an objective subjectivity about the interpretation of behavior. In the facts before you, particular facts before you, when you look at their personalities, their nature, their you'll be able to say, with a reasonable man, expect this particular petitioner to be able to continue to live with this respondent. So it is case and context specific when you're talking about behavior. Some of the behaviors that you've seen in case law are acts of domestic violence, nagging, sex starvation, like a kuribido and a pido, where somebody did not have sexual intercourse with the wife for 7 years and also made that person, the wife, to swear that she did not have sexual intercourse with another person. She took her to a juju, practitioner to go and swear. So excessive demand for sex, or not even having sexual intercourse, constitute behavior that someone cannot reasonably be expected to deal with. Gambling, isolation, social isolation, not accepting the other spouse, just relegating the spouse into the background and isolating the person from family, from friends. Workaholism, even when the person is overworking, is not really doing something against you, but it has an effect on the other party. So sometimes the behavior is directed against the other spouse. Sometimes behavior is the effect of the behavior is such that has an effect, it reflects on the other party or on the marriage. So workaholism, with the best of intention, the person may think that is working for the well-being of the family, but these are things that have been held to be behavior. Even not getting the employment, when you can easily get employment, you can reasonably get employment, has been held to be behavior that someone will not reasonably expect to live with forever. Overbearing attitude, dictatorial attitude, controlling personality, unemployment. These are some of the things that have emerged from case law as representing behavior. Now, if it's Section 16 of the Matrimonial Causes Act, then provides that lists some facts and acts that you would be said to be behavior under Section 15. But you must know that what is listed in Section 16 is they are just like indicators of behavior. They are not exhaustive. So the fact that what the petitioner is complaining about, it cannot be found listed under the Matrimonial Causes Act of Nigeria, does not mean that it will not sell in court. It actually constitutes behavior. We talked about looking at it as a reasonable person and thinking that should you expect that this person be able to live with this. So other behaviors outside the act can be proved. Under Section 16(1), you will now find some behavior that have been identified, a statutory list of behavior. Top 16(1)(a) says that since the marriage, the respondent has committed rape, sodomy, or bestiality. Since the marriage, you don't forget that. If he committed rape before he got married to the wife, that will not sell as behavior. Even if you are just getting to know about it, you may go and look for other grounds, but not under the Section 16 of the MCA. So rape, sodomy, or bestiality, if the person commits that, then it will be behavior. You see that one is not that it's not an act against the petitioner directly, but it has an effect on the marriage. And Section 87(1)(a) of the Matrimonial Causes Act says that once there's conviction for rape, sodomy, or bestiality, that will be evidence of adultery, okay? And that would behavior under Section 15(2)(c). Section 16(1)(b) talks about since the marriage, respondent has, for a period of not less than 2 years, been a habitual drunkard, or habitually been intoxicated by reason of taking or using to excess any sedative, narcotic, or stimulating drug or preparation, or as for a part or parts of such period being a habitual drunkard, and for other parts being habitually intoxicated. So someone that is has drug problem, drinking problem, to be caught by this provision. But it must be for a period of not less than 2 years since the marriage. And it must be habitual. Something that is habitual is repeated habit. It's not that once he took drinks and got drunk. Talking about something that is done habitually. Because the idea is that this kind of a person will not be able to control his affairs. He or she will not be able to control their behavior even within the confines of marriage. So it's likely to have an effect on the marriage. 16(1)(c) talks about since the marriage, the respondent has within a period of not exceeding 5 years, suffered frequent convictions. So it talked about habitual drunkenness, intoxication, convictions for crime, criminal tendencies, and personality. So if the person is a criminal, even if he was a good person before they got married, but since the marriage, that's what we're talking about, after you started this journey of marriage, the person has suffered frequent convictions. It's not just that that he steals or she steals or does something. There must be convictions, frequent convictions for crime, in respect of which the person has been sentenced in the aggregate to imprisonment for not less than 3 years. It might be 2 years, 6 months today, then after about 4 weeks or 4 months, another 6 months or whatever, the aggregate of which is not less than 3 years, then the person is caught by this provision. And the person is not only that suffering frequent convictions, habitually leaves the petitioner without reasonable means or support. Now look at this provision. It could be a man or a woman. It didn't say the man. So it could be the woman or the man that can generally be, suffering convictions. And the law requires not only that the person has been, frequently convicted and imprisoned, but that in addition must have, not met marital responsibility of leaving the other spouse with reasonable means of support. How that plays out in practice is another thing when you talk about the gender perspective. 16(1)(d) talks about since marriage, the respondent has been in prison for a period of not less than 3 years after conviction for an offense punishable by death. He has been, since the marriage, been in prison for a period of not less than 3 years. They got married in 2010. Okay, let's take 2024. So they got married in 2015. And 2016, the person was convicted and has been in prison, he's been in prison for a period of not less than 3 years. So maybe since 2016 that he was convicted, he's been in prison for an offense punishable by death. First punishable by death or by imprisonment for life, or for a period of 5 years or more, and still in prison at the date of the petition. In all cases, the idea is that when the person is in prison for such a long period of time, that the marriage has become an empty shell, and the other spouse should have the liberty to move away if necessary. Then there's 16(1), he talks about attempt to murder the petitioner. If since the marriage, the respondent within a period of 1 year immediately preceding the date of the petition. If he tried to murder the petitioner 10 years ago and you are just bringing the petition, it will not work. The law says immediately preceding the date of the petition, 1 year, he has been convicted of having attempted. So it's not as if you found it, this person tried to put poison in your food and then you shouted, and no, that's not what we're talking about here. In this context, it says within a period of 1 year immediately before the petition. So 2024, we're in February. So within the last 1 year backwards, if you want to bring a petition, this 2024 February now, you must be showing that within the last 1 year before now, the person has been convicted, not just arrested, not just accused, but convicted of having attempted to murder or unlawfully kill the petitioner. There must be a conviction. Or having committed an offense involving the intentional infliction of grievous harm. So it may not be that attempted murder, but any offense that involves intentional infliction of grievous harm or hurt on the petitioner, or the intent to inflict grievous harm or grievous hurt on the petitioner. Their safety is not to be jeopardized. The person's life is endangered, and the person has been convicted. Then you wonder if the person is not convicted, does it mean the marriage should continue? It may not necessarily be so, because there are so many other provisions of the law that we can use to support that kind of a situation. Since the marriage, the person has, guilty of non-payment of maintenance, and the law is saying that it's not that it's one. It says habitually and willfully failed through the period of 2 years since we got married. And in the last 2 years preceding the date of the petition, this is 2024 February. So 2 years dating back to 2022. Between 2022 and this 2024 February, for instance, the person has not has not paid maintenance for the petitioner. It must be habitually and willfully. If the person lost their job and would have paid ordinarily, that's not willful. If it's only once that they did not pay for one reason or the other, that's not habitual. It must be habitual, it must be willful, okay? And then it must have been a maintenance that is ordered to be paid under an order of a court, or so it must be that the court has ordered the maintenance, or maybe there was an agreement that was registered in court, a maintenance agreement between the parties, but has the sanction of the court. So it's like disobedience of a court order, in which case the person be held to have behaved in a way that the respondent the petitioner cannot reasonably be expected to live with. Or if the maintenance was agreed to be paid under an agreement between the parties, like I said. So willful and habitual refusal to pay maintenance, this shows that there is deliberateness, there is intentional disregard for the welfare of the other party. The person can bring this the petition under this grant. Or then the respondent is at the date of the petition of unsound mind and unlikely to recover. This, we under this edge, the law is looking at the mental state and looking at the marital relationship and what it needs. You need consortium. We talked about that. You need to cohabit. You need to have the marital, the normal effects of marriage, the vibes of marriage must be there. So if this person, if the spouse is at the date of the petition, that means that at the time you are bringing the petition, the person is still suffering from the mental, from the unsound mind. Then the law says the person must be unlikely to recover. So it must be the person must still be suffering from the unsound mind when you are bringing the petition. It must be unlikely to recover. Maybe there's medical evidence to that effect. Then since the marriage and within a period of 6 years, immediately preceding the date of the petition, has been confined for a period or for periods aggregating not less than 5 years in an institution where persons may be confined for unsoundness of mind in accordance with the law or in more than one such institution. So the law is saying that since the marriage, okay, at the date of the marriage, since the marriage, and for a period of 6 years preceding the date of the petition, in the last 6 years, so 2024 February, backwards 6 years. So within 6 years, away from backwards 2024 January, we're looking at, is it 2016 now, or how many years ago? Okay, within that time frame that we can talk of 6 years, the person, and as at the date you are bringing the petition, so not only 6 years before the date of the petition, and if the person must still be suffering it as at the date of the petition, it's of unsound mind, it's unlikely to recover, then it's under confinement for that period of within the period of 6 years. The confinement must be for a period or periods aggregating to not less than 5 years. So it could be 5 years confinement within 6 years, or it could be 6 years confinement. But it must be able to pick that 6-year frame before the date of the petition and explain to the court that in the last 6 years, maybe for the last 5 years at a stretch, he has been confinement at the place for mental, an institution for treatment of mental illness, or for periods that are aggregated. Maybe he was there for 6 months now, then went for 1 year, came back, was lucid, then came back, and then went for 2 years. But everything was aggregated not less than 5 years within a 6-year period that precedes the date of the petition. Then that can be said to be behavior. So now you be wondering, but that's not the person's behavior. That's just something that happened to the person, And if you look at the cases that have been used in English law, because a lot of these provisions have not been really utilized under the Matrimonial Causes Act. People didn't really have reasons to bring petition based on this. But in some of the English decisions, the issue had arisen whether behavior should be something that is deliberate act of the person, or whether passive activity can be behavior, or unintentional activity like the unsoundness of mind that we have talked about. Okay, be that as it may, let me just mention the fact that under Section 16.2, the law says that Section 16.1 is not exhaustive of behavior. So we have listed some of those things that cause you bringing that can represent behavior under the Matrimonial Causes Act, but it's not exhaustive. You can actually bring a petition based on a fact that is not listed under Section 16 and be successful. And one of the examples that have been typically cited is issue of royalty under the hitherto applicable matrimonial causes regime. We've talked about that in the past, that it was the matrimonial offense theory that operated, and one of the grounds is the grant of royalty. And it's been said that that is also still applicable here, since the acts that constitute, you don't have the word cruelty being mentioned under the MCA, you won't find it there, but it's any behavior that constitutes cruelty, which actually be behavior under the Matrimonial Causes Act. And you can see the case of Akimbuwa and Akimbuwa, that any conduct that endangers life or limb or gives reasonable fear of such is regarded as cruelty, and maybe basis of petitioning under the MCA. So most of the acts that we regard as domestic violence is age and day, acts of domestic violence which constitute behavior. Nana also established further intentional or malicious infliction of suffering on a person. It can be psychological, constant nagging. But there have been cases where the person was so psychologically abused that because she was thinking so much about the abuse, she had an accident. So it doesn't have to be a behavior that is listed in the components that I mentioned earlier. So behavior aside, don't forget that point. It's very important that Section 16 does not claim to be holistic, so to say. So in summary, Section 15(2)(c) talks about the fact that one of the ways you can establish irretrievable breakdown of marriage is that the respondent has behaved in such a way that the respondent cannot reasonably be expected to live with. It is not the behavior that is unreasonable. Please note that. It is not the behavior that is unreasonable, but the prospect of the petitioner continuing to be living with that person. Like the example that we talked about, the person of unsound mind. The person is of unsound mind due to no fault of theirs. Maybe it wasn't caused by anything that was intentionally done by them. So he cannot, he said the person is being unreasonable. So it's not the person that, it doesn't have to be that the respondent's actions or inactions are unreasonable, but rather it's the prospect of continual cohabitation and living together that is regarded as unreasonable. So two components are important: behavior and finding cohabitation intolerable. Both must be established. There's no definition of behavior under the MCA, but examples have been given in case law, and some of what constituents of behavior can be found in Section 16, which lists 7 examples of behavior. And Section 16 says that that list is not exhaustive. So you can actually cite behavior outside that section. You would also note the fact that there are case law examples of behavior. So when the person is able to prove these various components of behavior or any other one outside the Matrimonial Causes Act, it is said that the person has the marriage has broken down irretrievably, and the marriage could be dissolved under the law. So don't forget once again to like this video and to subscribe to this channel as we bring you more discussions on the position of the law or, in this regard.